Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Bankruptcy conversation. And during this segment of the show, ladies and gentlemen, I have creditors' rights and bankruptcy attorney Ron Steen of the Thompson Burton PLLC firm, calling in all the way from Franklin, Tennessee. Now, Ron, who is considered to be an authority in the area of bankruptcy and creditors' rights, will be talking to you today about what commercial landlords should know when a retail tenant files bankruptcy. Now, that sounds like a very important and interesting topic. So, if you are one of the many creditors in bankruptcy within the Franklin, Tennessee area, and you're wanting to know more about today's topic, you might want to stop what you're doing. Give yourself a break for the next 15 to 20 minutes or so. Log out to Facebook, Twitter, Instagram, or anything else which may cause a distraction. You know something, you might even want to grab yourself a notepad and pen and take some notes as we listen in to what Ron has to share with us today. So with that said, let's not keep him waiting any longer. Welcome to the show, Ron.
Thank you very much. I'm glad to be here, and I appreciate the opportunity.
And we appreciate you taking the time out of your busy day there in Franklin, Tennessee. With that said, Ron, let's just jump straight in with our first question for the day. Briefly, in your own words, Ron, describe the kinds of people who you serve and the various types of situations they find themselves in when they come to you for your help.
Well, we typically represent the creditor side of the bankruptcy equation, and that runs the full spectrum from financial institutions to commercial landlords to unsecured creditors that don't have any collateral, and they typically come to us after the debtor has either defaulted or experienced severe financial distress. Hopefully we get them before they experience a bankruptcy complication, but oftentimes it's after the bankruptcy case is commenced, and they come to us wanting to know what can they do, how can they protect their investment, their money, what are the risks involved, and what the process is going to look like. And so that's what we typically address, is the creditor side of that equation.
Okay, thanks for sharing that, Ron. Now that we know who you help, before we go any further, it goes without saying that anything you share with us from this point on is not legal advice or legal assistance. It's purely for the purpose of sharing information. Now, with that said, I am sure there are many, Ron. However, of all the misconceptions you come across while you're out there helping your clients, what's the most common one that you have to deal with on a regular basis?
Well, within the context of a commercial landlord-tenant relationship, and specifically with retail tenants being involved, the biggest one that we have to overcome is that the bankruptcy is a death knell for the lease and the relationship between the landlord and the tenant. Mm-hmm. That's probably the biggest. Secondarily to that is that the debtor is going to be bound by all the terms of the lease in the bankruptcy process. And those two misconceptions are really difficult for us to try and get a landlord to understand. I mean, that's typically what they come with when they visit us, is, that the lease is dead, or that if the lease isn't dead, that then the debtor has to perform everything to the dot and jittle in the lease. Mm-hmm. And those just aren't true.
Right. So based on what you just shared with us then, Ron, and obviously keeping your client's confidentiality in mind, can you share an example of how you have helped somebody, or how you would go about helping somebody who came to you with those challenges, those misconceptions you just described, and what kind of transformational results you were able to gain for them, or you would be able to gain for them, please?
Sure. Well, a number of years ago, we were involved in a what we call a mega bankruptcy case, which is one that has debts and assets in excess of say, $250 million. And it was a well-known retailer nationwide. And we represented several landlords, and they came to us with those misconceptions. The first one being that, well, gosh, they filed bankruptcy, now the lease is dead. So we had to and we're able to show the client that that's not the case, that the bankruptcy code provides for very specific rules when you're dealing with leases of real estate. And that's Section 365 of the bankruptcy code. And more specifically to that, there are very specific provisions within that code section that regulate the lease with respect to shopping centers and retail customers. And so through that process, we were able to point out and position them in such a way that the lease could still continue forward, that the debtor could assume that lease and cure whatever defaults existed at the time of filing and move forward and get them back to where the tenant was on a paying basis going forward and complying with the terms of the lease. The second one was a little more difficult, and that is, in that specific case, when we were representing these landlords, they all were of the impression that every single provision in the lease was binding and that the debtor could not move forward on the lease in the bankruptcy process and even after, unless every single covenant and restriction were complied with. We had to disimbue our clients of that knowledge and point out to them that statutorily the bankruptcy code is designed to give debtors a fresh start. And within that framework, they are able to maneuver through some of the more onerous restrictions and provisions that leases sometimes contain. And by doing that, we were able to craft a result that, while some provisions were not enforced, there were backup provisions that could dovetail with that and get them where they needed to be.
So, as a reminder, ladies and gentlemen, we are speaking with Ron Steen, and today's topic is what commercial landlords should know when a retail tenant files bankruptcy. Now, with that in mind, and for those creditors in bankruptcy who are listening in right now and they wanting to know more, what's the most common but unknown pitfall that they might not, however, should be aware of no matter what situation they find themselves in, Ron?
Well, in this particular topic, it really starts when the landlord begins to notice that their tenant is in some financial distress. And that can take on any number of forms. Most typically, it's going to be late payments or payments that are past due. It could be based upon percentage rent, which is usually based upon sales as well, and a declination in the amount of percentage rent that's generated over a period of time. And so knowing those markers is essential to any landlord, and they need to pay attention to the financial condition of their tenant. They need to pay attention to what the tenant's overall performance looks like, and that really will help them try to stay ahead of the problem. So I think the first and biggest issue that they need to realize is you want to stay on top of this issue from the start. Most of the times, the biggest pitfall we get is everything looked to be fine, Ron, but all of a sudden we get a bankruptcy petition. Well, there were probably road markers along that path that indicated that they were headed in this direction. And if the landlord or the creditor is able to identify those road markers and get counsel in quickly before the bankruptcy happens, a lot of times you can avoid having a bad situation and a bad result. That would be the first thing. The second piece of information is it's crucial for those folks to know their real estate market. A lot of times we will have clients that will come in and say, I've got a problem tenant. They want to renegotiate the lease, and that particular landlord client will feel obligated to do that because they don't understand the market. They don't understand the risks and potential benefits there. And so what will happen is they will unintentionally agree to a deal that is bad for them. And by that, I mean they either agree to a renegotiated amount where they didn't have to, such that they're going to take less rent, or they will pass up an opportunity to take a better deal to try and avoid a bankruptcy situation. And having competent counsel advise you. So knowing those road markers, seeing that, getting competent counsel involved at an appropriate time will really avoid the bad things that could result if you're not paying attention, or to put it bluntly, to be asleep at the wheel. So those are two of the big problems and things that I always want folks to understand before is you need to be paying attention all along, because a bankruptcy doesn't just come out of the blue. There's usually indicators along the way. And I don't want my clients to feel obligated to take a renegotiation lesser rent, because really you need to, as a landlord, you need to understand that the market may not bear the rent that they're currently being charged, or it may say what they're doing is an artificially lower amount. So if the lease is terminated, we're fine with that, because we can then relet the premises to someone else at a better market rate. So there's a push and a pull, and only through competent counsel and knowing the road signs and having adequate, discussions with not only your attorneys, but with your real estate professionals that you use, whether that be an agent or people internally in your business structure that know that area and know the market, you can really have a better picture and grasp on what there is available pre-bankruptcy.
Fantastic. I get a sense that we're only scratching the surface here, and that you could speak possibly for a whole day around this particular topic. However, we are limited by time, Ron. Well, let me ask you this. How many years have you been a practicing attorney, Ron?
I've been practicing for over 20 years.
Right. So would it be fair to say that within that 20-year span, you have helped hundreds of clients?
Absolutely.
Okay, so let's just imagine this then, Ron. It's any day of the week. It's a Monday, Tuesday, Wednesday, regardless what morning. Your alarm clock kicks in, it's 6 a.m., 7 a.m., and you wake up with a full day's work ahead of you, helping your clients, helping those clients, those creditors in bankruptcy. After 20 years and helping hundreds of cases, how does Ron Steen feel on a morning like that?
Well, I feel called, feel blessed. It's one of those situations where you're excited to perform for your clients. The practice of law is not just a job. It is a all-encompassing profession. And so you derive success from doing a job well done, I won't say meeting, because that's just kind of a baseline. We strive to exceed our clients' expectations. And so having the ability to work with them to provide the results that they are entitled to is very fulfilling. And there's always points in the day where you need to stop and reflect, but that does not mean that you need to sacrifice your customer service at the same point. So we take that, and I take that to heart every day, and enjoy the prospect of a day's work and the progress that it can bring for our clients.
So let's continue speaking a little bit more about yourself. If you could, just spend a few moments sharing some information about your background, your formal education, and your experience as it relates to the topic of bankruptcy and creditors' rights.
I went to law school in 1993 at the University of Alabama and graduated in 1996, and had always had an interest in the bankruptcy world, because bankruptcy intersects with various points of law. If you think of the law in general as a wheel, bankruptcy is going to be your hub, and the spokes that run to the edges of the wheel are the various other points of law, and so they all intersect with bankruptcy. And so that to me is very exciting, because you have to understand how bankruptcy works and how they intersect, and you also have to understand the other points of law that are presented. I enjoyed the bankruptcy side from a creditor's point of view, because of the variety of the issues presented in a commercial context. And I started getting involved in this right out of law school. I mean, my first, foray into the legal profession was in the bankruptcy realm, and has been since that time. And very early on, Creditors' work was more appealing because of the nature of being able to find a proactive rather than reactive strategy was appealing. And that kind of brought me into contact with a lot of landlords that had these issues come up. What can we do? How can we do it? That gets your brain juices flowing, so to speak, and finding these creative ways to do it. And so I've been doing this now for, like I said, over 20 years. Mm-hmm. And retail in and of itself is very particular. As I mentioned earlier, the bankruptcy code has very specific sections on retail clients, on shopping centers, and that niche practice area is very helpful because it presents a lot of opportunities, especially in today's economy. You're starting to see all kinds of traditional retail giants suffer, whether it's Sears or JCPenney's or Macy's. All of those are experiencing some woes and are closing stores, and that begs the question of, well, what happens to those leases? And so this is just one of those areas that's really going to, unfortunately, I think, expand in its presence over the next few years.
Okay, Ron, so we are approaching the end of the show. So I'd just like you to picture the kinds of creditors in bankruptcy who come to you for your help, and they are wanting to know more about what commercial landlords should know when a retail tenant files for bankruptcy. Now, with that picture in mind, Ron, what final thoughts would you like to leave with them before we close out with our last question for the day?
Well, the advice I would give to them and what I would want them to know, there's really three things. You need to know your market. You need to know your lease. And by that, I mean you need to know, is this a triple net lease where you're passing things on to your tenant for their responsibility? You need to understand what your default provisions are, if there's a way to avoid a default or a way to declare default. And the other thing is you need to know that it is to your definite benefit to understand the road signs, and when you start seeing those, get in touch with counsel as early as possible. Those three things are crucial, and we're glad to help creditors understand those more fully and explain those in more detail than we have time for here today, because obviously it's a very complicated and difficult area of the law to understand. But those three things are absolutely crucial.
So if there is a creditor who's listening right now, Ron, and they feel they want to know more about, what commercial landlords should know when a retail client files for bankruptcy. If that's the case, what would be the best way to find you? How could they reach out to you, Ron?
Well, I do not screen my phone calls, so the best way to get in touch with me is to call me directly, and my direct number is area code 615-465-6010. If a phone is not convenient and you don't have the time to engage in a lengthy conversation, you can send me an email, and I will respond to that directly. My email address is Ron, RONN, Steen, STEEN, at ThompsonBurton.com, and that's ThompsonBurton.com.
Okay, that's all we have time for today, folks. Again, as a reminder, that was Creditors' Rights and Bankruptcy Attorney Ron Steen. Thank you so much for sharing so generously with us today, Ron. You have certainly demonstrated within the short amount of time we've had that you are a true educator, advocate, and trustworthy advisor for your client's success. So thank you.
Thank you very much. I appreciate the opportunity.
You are so welcome, Ron. And I'd also like to say a big thank you to you. Yes, the listener. Thank you for joining us on, I think, what I can only describe as a very insightful and informative conversation. I know we've only scratched the surface of what Ron can share in terms of insights and experience. But thanks for joining in on this conversation with one of the leading creditors' rights and bankruptcy attorneys in the Franklin, Tennessee area today. Just as a reminder again, his name is Ron Steen. Make sure you do check him out. Give him a call. Like you said, he doesn't screen his calls. That sounds like a great place to get started, or maybe even drop in an email if that's what you prefer. Regardless of what you do, I am sure that after today's conversation that you're going to be in good hands. So that's it, folks. Again, my name is Stewart Andrew Alexander. We'll be back shortly with some more leading bankruptcy and creditors' rights professionals in this, our series of Let's Talk Bankruptcy Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.